So, the first question we ask is whether the court has jurisdiction. Of course, before jurisdiction exists, there are some preliminary questions like res judicata, res sub judice, which we discussed in our earlier lecture. But then the question comes that of jurisdiction. Jurisdiction is basically the authority of the court to decide a matter. Jurisdictions can be of three kinds: subject matter, pecuniary and territorial. Subject matter jurisdiction of the CPC is given into section 9 of the CPC itself, which says, the courts shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, exceptions of suit which are cognizable either is expressly or impliedly barred. So, the general rule is that all suits of civil nature, the civil courts take cognizance, that is decide the matter, but it can be expressly or impliedly barred. This barring does not happen under the CPC, it happens under the other acts. For example, section 34 of the DRT Act can says that jurisdiction of the civil court is barred. That would be read with section 9 of CPC to bar the jurisdiction of the civil court. Now, this has created, see how it operates is basically I can put it this way, that if you think this whole thing as suits of civil nature originally, then they cut out this slice which is debt recovery, then they cut out another slice which is consumer, then they cut out another size which could be say revenue, so on and so forth, right. So, what is happening is what is formerly the civil jurisdiction is getting divided into a number of tribunals. The structure of the courts then becomes something like this, that you have the civil court system, you have the high court, you have this, you have the district court, and you have the subordinate courts, the high court having of course supervisory jurisdiction over all of them, and of course above this is Supreme Court. The Supreme Court, so far as the Supreme Court has happened, the CPC does not really have lot to say about the Supreme Court. Supreme Court is guided mostly by its own rules, so CPC would be applicable to the civil proceedings before it. The tribunals on the other hand have their own structure. A typical example of a tribunal is that of the consumer tribunal. So, consumer tribunal, you start at the district forum, then you have the state forum, then you have the national commission. So, you are not going back to this structure of civil court at all. Then above the national commission you go directly to the Supreme Court, right. So, this is what happens. So, where section 9 read with provisions of National Consumer Protection Act would exclude the jurisdiction of the civil court and create this separate structure. So, this is known as tribunalization. Remember, tribunalization excludes the jurisdiction. Usually what happens, it is that the jurisdiction of the civil court is excluded to an extent, but it may not be fully excluded. So, it might be excluded either partially or entirely, right. So, the level of exclusion varies. This was clarified by the Supreme Court in a case which is known as Dhulavai versus State of Madhya Bharat. I think this Dhulavai case, it is in your notes. So, the court, the Supreme Court laid down the principles for exclusion. First, you have to see whether the statutes gives finality to the orders of the special tribunals. This structure, when there is an express bar, an examination of the sufficiency of the remedies provided is necessary, but not determinative. When the bar is implied, it might be decisive. So, if it is an express bar, you know that okay, it is barred, but if it is impliedly barred, the court should consider whether the remedies that are given by the tribunal is sufficient. That is what the plaintiffs are seeking. Third test, challenge to particular provisions of a particular act cannot be brought before tribunals constituted under the same act. So, for example, if you are challenging some provisions of the National Consumer Protection Act, you cannot do it in a tribunal constituted under the act. For that, you have to either, for constitutionality, you have to go to the High Court, or for any other kind of challenge, you might have to go to this civil court system. Then 4, when a provision is declared unconstitutional, constitutionally challenged, so if it is declared unconstitutional, you can again go back to this court system. Yes, then rule number 5 and 6 was pertaining to the specific year of the case, because in the Dhulabhai case, the question was whether whether you can file a suit for restitution of damages where with effect to a tax refund, that is the extent of exclusion with reference to a revenue tribunal, not a civil tribunal, right. So, these are the basic rules, that first you see if it is an express bar. If it says no civil court would have jurisdiction, then that is the end of the matter, it is barred. If not, if it is an implied bar, you see that A, whether the statute is giving finality to the orders, it is saying the orders of so and so, such and such tribunal will be final. You also can have a look into the sufficiency of the relief, if that tribunal is giving you entirely the relief. And you then finally, you would also see if it is a challenge to the constitutionality or ultra vires to the tribunal, that will have to go back to the civil court system, that cannot be before the tribunal itself. So, that is about the exclusion. So, the first thing you should look is whether or not your matter is covered by the civil court. Is it something that you can bring before a civil court, right? You would begin asking the other questions subject to the answer to that question. If the civil court does not have jurisdiction, then the question of pecuniary and territorial jurisdiction does not even arise. Then the issue is that of pecuniary jurisdiction. Now, pecuniary jurisdiction as such is not given by the CPC. It comes from various places. It comes from the High Court rules, it comes from other things, other statutes. The CPC only lays down in section 15, if you have a look at section 15, every suit shall be instituted in the court of the lowest grade competent to try it. So, it simply says that, say for example, if you have a matter for 10,000 rupees and the lowest court have, say the district court have 1 lakh and the High Court have 1 crore original pecuniary jurisdiction, and your matter is of 1 lakh, you should start here, not here. Okay. Now, subject matter jurisdiction. The CPC lays down elaborate rules as to the subject matter jurisdiction. However, these rules are confined to only when the matter is entirely within India, right. A somewhat different set of rules would apply if there is a foreign element involved, right. But first, look into what are the rules that the CPC lays down when the matter is totally Indian, right. We start into with section 16. Section 16 says, subject to the pecuniary and other limitations by any lawsuit so and so, for the recovery of immovable property with or without rent or profits, partition of immovable property, foreclosure, sale, redemption, case of mortgage so and so, determination of any other right or interest in immovable property, compensation for wrong to immovable property so and so shall be instituted in the court within the local limits of whose jurisdiction the property is situated. There is a proviso, I will just come back to the proviso later, right. So, for immovable property, that is your land, house so and so, the basic rule is that of lex situs. That means, you are going to commence your action where the property is situated. So, you have a house in Bombay, you would start the action in Bombay. You won't go back to Delhi and start the action, even if it is convenient for you to do it, right. It applies for almost everything pertaining to immovable property, recovery, partition, foreclosure, sale or redemption, any other kind of interest. Say for example, if you are pressing an easementary interest or something like that, compensation of wrong, somebody has damaged your house, you wish to seek a compensation, you should ideally start where the house is situated. For the recovery of movable property, actually under distraint or attachment, if movable property is under attachment, say for example, the court has attached your movable property somewhere, this is somewhat different from rule F is somewhat different from A to E, then the action is going to commence where this movable property is being attached, right. Now, there is a proviso to section 16. Proviso to section 16 says that provided that a suit to obtain relief respecting or compensation for wrong to immovable property held by or on behalf of the defendant may, where the relief sought can be entirely obtained through his personal obedience, be instituted either in the court within the local limits of whose jurisdiction the property is situate, or in the court within the local limits of whose jurisdiction the defendant actually voluntarily resides, carries on business, personally works for gain, right. So, if it say for example, I am just holding the title documents of your property and all you have to do in respect of your to get the relief in respect of that property is to secure it from me, then you need not file it at the place where the property is situated, but where this defendant, the term that used being voluntarily resides, carries on business or personally works for gain. That is to say, he resides, ordinarily resides, he carries on his business or his workplaces. Now, once again section 16 makes it very clear that this rule applies only when the property is situated in India. If it is a property situated in say England and you have some dispute regarding that property, then section 16 will not come to your rescue. So, section 16 pertain to immovable property, right, like land, house, etc. Now, what happens if the immovable property is in the jurisdiction of different courts? Say for a property, so there are these two districts, Sonipat and Panipat, and your property encompasses both. It's crosses the state district boundary. Then you can file it either before the district court of Sonipat or district court of Panipat. What if you do not know where it is, like you are not entirely, the property's demarcation is not very clear or not very certain, you are not sure where the property is, then also you can file anywhere, right. You look into rule 18. Yes. Now, so rule 16 to rule 18 pertain to immovable property. Rule 19 comes to compensation for wrongs for person or movables. Okay. So, where a suit is for compensation for wrong done to a person or to movable property, if the wrong was done within the local limits of jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of jurisdiction of another court, the suit may be instituted at the option of plaintiff in either of the courts. So, take example for this. So, A lives in Delhi, B lives in Bombay, A beats up B, A assaults B in Kolkata. So, where would it lie? It either lies where the cause of action arose. What is the cause of action? Assault. So, it either lies in Kolkata or where defendant, that is A, resides, which is in Delhi. The term they use is resides, voluntarily resides, resides, carries on business or personally works for gain. So, Delhi here is his place of residence, but suppose you do not know where A lives, but you know that A works for a company in Delhi. So, his place where he carries, the term used is personally works for gain, is there for Delhi. You can still file it in Delhi. Or he carries on his business. So, you know that he has a shop somewhere in Delhi. So, that is also sufficient. So, it is based on two things, either A, where the defendant, where the wrong was done, or the defendant resides, three things, resides, carries on business and personally works for gain, these three things. Now, 16 to 18 pertains to immovable property, 19 pertains to wrongs done to movable property and person, 20 is the generic section, it applies to everything else, right, which does not come in the sweep of the first two series of sections. So, section 20 reads, subject to the limitation aforesaid, every suit shall be instituted in the court within the local limits of whose jurisdiction the defendant or each of the defendants where there are more than one at the time of the commencement of the suit actually and voluntarily resides or carries on business or personally works for gain. Any of the defendants where there are more than one at the time of the commencement of the suit actually and voluntarily resides or carries on business or personally works for gain, provided that in such a case either the leave of the court is given, so and so, and C, the cause of action wholly or partly resides, right. Let me just explain this with an example. So, suppose there is a contract between A, B1, B2 and B3. They are separate parties, okay, fine, just consider them C and D. So, in subsection 20 subsection A, the situation is all three of them are in the same place, right. We know that these A, B, C and D has a shop in the district of Sonipat. So, all three of them personally has a business in Sonipat, or we know that all three of them works for a company in Delhi. So, in that case all three of them works in Delhi, or we know that they all are from Noida. So, they have a house in Noida. So, they all are from Noida. So, in any case these factors are same for B, C and D, in which case you can file it where this B, C and D are. So, you can file if it is they have a shop in Sonipat, you can file in Sonipat. If they are residing in Delhi, you can file it in Delhi. If they are working in Delhi, you can file it in Delhi. If they are if they are residing in Noida, you can go and file it in Noida. But all B, C and D has to be at the same place, right. The second option is, what if this, in case of this contractual dispute, this B, C and D are from different place. This B lives in Noida, C lives in Delhi, D lives in Sonipat, and their workplace or their place of business are not the same. What do we do? So, what we do is we file in one of the places, we file it in Delhi, or we file it in Sonipat, or we file it in Noida, and we seek the leave of the court to implead the other two there. Say for example, B lives in Sonipat, so we filed it in Sonipat and we seek leave of, A seeks the leave of the court to the leave of the court is granted to make this and this a party in that suit. That is the second option, which is given in B. C is where the cause of action arises. So, this cause of maybe that A and B had a contract, that contract was signed in Bombay, right, or the breach of the contract, or the contract was performed in Bombay. So, when the contract was breached, the cause of action, that is the facts giving rise to the right to sue, arose in Bombay. So, you can file it in Bombay then. Okay. So, the cause of action arises. So, 20C gives you 3 choices. A, when all the defendants are from same place, either living there or working there or having a business there, file in that place. Or if the defendants are from different places, file in one place and seek the leave of the court to join the others who are not from there. And C is file at the place where the cause of action arose, right. So, these are the facts there. Now, there is an explanation that says a corporation shall be deemed to carry on business at its sole or principal office in India or in respect of any cause of action arising at any place where it has a subordinate office. So, a company a company carries on business at its place of incorporation or where it has a subordinate office, right, because company is not a human being, company is a juristic person. So, for company we deem the place of incorporation to be their place of business, right. Now, all these rules apply only when all the parties are Indian and the whole cause of action arises in India, right, because CPC itself does not extend outside India. Now, 2 things can happen. What happens if the parties themselves choose a jurisdiction, that is the parties through their contract choose a jurisdiction. And the second question we need to ask ourselves, what happens when there is a foreign element that is involved. So, these 2 requires a detailed examination. First, let us consider what would happen if the parties choose a place of contract. So, just take another example. So, A is from Kolkata, B is from Delhi, they enter into a contract at Bombay, and in that contract they write that in case of dispute the parties shall approach the High Court of Bombay, right. So, this is known as a jurisdiction selection clause or a forum selection clause. So, okay, now see the difference. So, in this case the contract was entered into Bombay. So, if the contract is breached, the cause of action arose in Bombay, and in any case the court in Bombay would be one of the courts which would have jurisdiction under the CPC, right. So, the basic law is that the parties can choose a jurisdiction so long as it is one of the proper jurisdiction, as long the court has proper jurisdiction. But suppose, take a second example, the contract has been entered into Bombay, everything was connected to Bombay. The parties said that in case of a dispute, we will go to Ahmedabad, right. Ahmedabad has nothing to do with the contract, neither the parties are from Ahmedabad, nor the contract was entered into Ahmedabad, nor was the contract performed into Ahmedabad, right. So, now the parties, however, chose Ahmedabad as a jurisdiction because out of a whim or it somehow seemed convenient to them, right. But the Ahmedabad itself has nothing to do with the contract. So, in the former case, Bombay, where the contract was entered, would have some connection with the contract anyways, but Ahmedabad, except for the party choice, would not have the contract. So, the Indian law is that the parties can make a choice of a jurisdiction or choice of a forum, provided that forum would be one of the forum courts to have proper jurisdiction to begin with, right. So, this was given in these 2 cases. and that of swastik gas. This is 2013, I think, yeah. So, the two basic question was, can a court which is completely does not have any proper jurisdiction, does not have any connection with the matter, can be given jurisdiction by through a contract between the parties? The answer is no. But if a court already has a proper jurisdiction, and I mean, as you see under this 20C rule, like 3-4 courts, different courts would have a proper jurisdiction, right? Parties can just make a choice between one of them, right? So that is the Indian law. Then this choice of jurisdiction can be of two kinds. One can be exclusive jurisdiction, that is, yes, we are going to go to this court and this court only. And then the second could be a non-exclusive jurisdiction. A non-exclusive jurisdiction is best understood to be a kind of preference, that the parties have decided we would rather go to this court, right? So one of the things which was decided in this ABC laminate and swastik gas was, how do you recognize if it is exclusive or non-exclusive jurisdiction? So exclusive and non-exclusive jurisdiction is decided based on the party's choice, based on the party's intention. It is not really based on wordings. So what the court has to do is to read the contract in totality to figure out what kind of jurisdiction selection the parties entered into. So that is the rule in India. Now, the really difficult question would come if there is a foreign element involved. Like even this jurisdiction selection clause, as I told you, was between two Indian parties with a matter which is entirely confined to India. But what would happen, say for example, there is an American party it's a US company. So, A was selling B goods. Let's take the second example we took in the first lecture, that A was supplying goods to B and B was paying A in installments. Now, one cache of goods turned out to be less satisfactory than the contractual standard, and B, the Indian company, stopped the payment of money. Then what happens, that A goes to an US court they file a suit for specific performance, and B comes before an Indian court and files a suit for damages because their substantive clause, their supply of substandard goods has damaged my business, right. Now, you see two parties have approached two different courts in two different laws. The CPC does not extend to US. The US procedural laws do not extend to India. So, there is absolutely nothing in the CPC which is going to help you solve this matter. Well, at one, so this is, here we take a small detour from CPC and come into the domain of what is known as conflict of law rules. Conflict of law rules basically help you to with matters that has a foreign element in it, right. At some point of time, an Indian lawyer may have gone through his domain. So, here we are exiting CPC and entering into domain of what we call conflict of law rules. conflict of law rules help us basically determine cases involving a foreign element, right. So, the case here is this, that you have A before an American court, B before an Indian court. There are two ways this can be solved. One way is that we apply the rule of lis alibi pendens. Lis alibi pendens is similar to our section 10, only that section 10 itself does not apply to a foreign matter, but the wider principle of lis alibi pendens matters. Lis alibi pendens says that whichever court is seized of the matter will let it decide first. So, the Indian court is going to let the American matter proceed and then enforce the foreign judgment if this has come first, or the Indian or the American court would let the Indian matter proceed first if this has commenced first, right. So, whoever shoots first wins basically in this scheme. Why the courts would do it? The basic understanding is that the principle of comity, that you give a proper respect to a court of a foreign jurisdiction. The Indian court believes that okay, the Americans can give a good judgment in the matter, or the Americans believe okay, the Indians can give a good judgment in the matter, and just let the other party proceed, right. A rule of lis alibi pendens of course operates, I mean it would operate almost exactly as the same principle of section 10. Section 10, if you remember, we had talked about matter directly and substantially an issue. So, for lis alibi pendens rules to apply, so these two matters have to be directly and substantially basically the same. The language we are using it in this context is factual basis of claim, and the laws are same with a view of obtaining the same basic outcomes. Not a formal test, it is not a technical and procedural rules cannot be used to defeat the outcome, right. So, this was given in this case. Writing it down, it is very difficult spelling. Fabric. This case lays down the principle of lis alibi pendens, which says that for lis alibi pendens to apply between these two matters, the factual basis of the claim and the laws have to be same with a view of obtaining the same basic outcome. It is not a formal test, technical and procedural rules cannot defeat it. So, understand it for all practical purposes similar to section 10, only applying to a foreign matter. However, common law courts, generally speaking, do not apply this principle. The test which is more popular among common law jurisdictions is known as the forum convenience test. Let me write it down. That is to say, the court tries to figure out where the matter can be decided better logistically and also better from the view of access to justice, right. So, this originally of course comes from admiralty jurisdiction, but it is not any more confined to admiralty jurisdiction. The most significant case that we often read these days is the Gulf Oil versus Gilbert case, which was this is a very old case, 1945, I believe, 45, 46 somewhere. This case gives up the FNC test. So, in the case what had happened was that the respondent plaintiff brought an action in the Southern District of New York. This is an American case, by the way. One thing about America, the United States does not have a CPC. So, for every American state is like a different country for the purposes of this civil procedure. So, if we did not have the CPC between the Indian states, we would be reduced to the same situation. That creates a lot of confusion, that creates a lot of scope for litigation, but the presence of the common civil procedure code among the Indian jurisdictions has prevented that outcome. So, he brought an action in the Southern District of New York against Gilbert. The company, however, resided in Lynchburg, Virginia, where he operated a public warehouse. The petitioner defendant carelessly handled So, Gulf Oil handled a warehouse of tanks so and so, causing a fire hazard. So, Gilbert was seeking damages worth $365,000 with cost and disbursements so and so. So, the defendant wanted to sue you in New York. Why? Because his logic was that the court, that the jury in Lynchburg, America, of course, as you understand, they have jury trial, the jury being laymen are not really capable of handling such a large claim. See, in 1946 and 47, $300,000 was a lot of money, right? So, in that context, the court considered what is a convenient forum here. Is it New York or was it Lynchburg, Virginia, right? So, this is where. The case gives you the factors that are to be considered in considering whether a forum is forum FNC or not. The first factor is, of course, the logistical factors like the location of witness, evidence, etc. The second set of factors is whether hardship is caused to somebody. Then the court is going to consider whether, like in an FNC consideration, the Indian court would consider about the American court, or the American court would consider about the Indian court, that whether the other court makes expeditious use of judicial resources. Do not worry, all this is in your notes, so it's there. Then choice of law. For example, if the parties have chosen the Indian law, an American court ordinarily would not decide it. I mean, they can decide it, but they would not, because it is more conveniently than decided by an Indian court. Then there has to be questions of public policy. Then there has to be question of vexatious motive by parties. Let me explain you the principles. The first principle in deciding whether I would exercise jurisdiction or the other court would exercise jurisdiction is, of course, where the evidence is located, right? Overwhelmingly, that is the first question that you ask. If you remember, in the Bhopal gas leak case, the government of India had actually first approached the American courts for relief. The question that was asked before the US District Court was whether US should be the convenient forum or should the matter be tried by the Indian courts. The American courts decided that they are not the convenient forum. Why? Because they decided the whole, I mean, for many other things, but they decided the basic pivotal question before them was where the evidence and the witnesses are located. They figured out that everything is in India, the witnesses in India, the event happened in India, all the paperwork is in India. So, the matter is better decided by an Indian court. American court did not accept jurisdiction there. Then, I mean, I would take 2 and 5 together. Is hardship being caused to the defendant? Like, if I am going to move this matter, the Indian court would consider that if I am going to move this matter to India and this company has no presence in India, will I be causing them fundamental hardship? And also, is B bringing the matter in India only so as to harass A? Is it their only motive? So, that is something the court will apply its spine to. Then the third issue that they would consider is that of the adequacy of the alternative remedy, expeditious use of judicial resources. So, suppose if it is before the Indian court who is doing the FNC analysis, they would see, will the American courts be able to competently handle the matter? Will they have the proper judicial, will the decision come in some good time? Now, interestingly, there was, I mean, often this has been decided against India. How? If you read the 188 Law Commission report, you would see the Law Commission of India is actually complaining that the American courts have taken jurisdiction even when the Indian courts should have properly have jurisdiction. That is, the American courts have held India to be FNC because Indian courts take too long to decide matters, right. So, this is actually a heavy question that has to be asked, that whether the court on the other side, that is whether the other option is actually prolix and long-winded. Then public policy. Suppose I am considering the Indian court is doing this FNC analysis. Indian court would consider, suppose if I let this matter go to the other court, will I be outsourcing one of my public policy? How it is happening? Suppose contracts of corruption are not enforceable in India. Say for example, you and I enter into a contract that I would give you some money and you would influence the government. Such a contract is not enforceable in India, right. But however, in past they have been enforced in several other jurisdictions. These are called influence contracts or influence peddling contracts. So, such a contract comes before an Indian court. The Indian court would think that if I let this go to the other court might actually enforce this contract and thereby do something which is against my public policy, right. In such a condition, such a circumstance, the court is going to hold this court to be an forum non-convenience and seize the matter themselves and decide. So, subject to these principles, when you have a foreign element, the CPC rules would be ousted and you will use this test for deciding jurisdiction. Now, once the Indian court says that, okay, fine, I have jurisdiction, how will you prevent A from proceeding with the matter? There is a mechanism for it. This is known as an anti-suit injunction. An anti-suit injunction is directed against a party and not against the court. So, the Indian court is going to issue an anti-suit injunctions on A and ask them not to approach any other court for decision, but this would be directed against A. This won't be directed against an American court, because obviously sovereign court of one country cannot give an injunction against court of another country, right. So, this is long and short the FNC analysis. So, this concludes our discussion on jurisdiction. Of course, you would have very detailed notes on all these heads and I hope you find it useful. So, thank you for your patience. Let us move on to the next topic.